In South Africa, land is never just land. It is memory, it's inheritance, it is blood. And when law meets desperation, the question is not only what is right, but what survives. A storm is brewing in Parliament, and at its heart is a bill that could redefine the battle between private rights and public need. The Democratic Alliance has tabled an amendment to the PI Act, the Prevention of Illegal Eviction and Unlawful Occupation of Land Act, a law originally born from the ashes of apartheid, built to protect the vulnerable from being thrown to the streets like shadows in the dark. But now it's being sharpened, reforged, questioned. And depending on where you stand, it's either long overdue or dangerously close to violating the very promise of our Constitution. So what is the PI Act? Enacted to give effect to Section 26 of our Constitution, it guarantees everyone the right to adequate housing. But it doesn't just stop at words. It builds a legal shield. Before someone can be evicted from land, even if unlawfully occupying it, the courts must consider their dignity, their age, whether they are children, whether they will sleep under the stars with nowhere else to go. It was a law designed with humanity in mind, but also a law forged in idealism. And idealism, when not tempered by real-world consequence, can become its own form of injustice. Why change it? Because South Africa is witnessing a surge in illegal occupations. Not all of them rooted in need. Some are allegedly orchestrated by political syndicates or criminal networks who manipulate desperate communities for gain or power. Property owners, many of them ordinary people, not faceless corporations, find themselves unable to reclaim what is legally theirs. Municipalities burn through budgets not to build housing, but to litigate endless eviction applications or protect undeveloped land like it's gold. And so the DA has proposed this, a private member's bill that seeks to recalibrate the law, not tear it down, but tighten its weakest points. What does the amendment actually say? There are three sharp edges. Criminalizing incitement. It becomes a crime to organize, encourage, or incite unlawful land occupation, even if no money is exchanged. It targets syndicates, the puppet masters, the ones who profit from chaos. Clearer criteria for the courts. Judges would now be bound to consider not just circumstances, but specific defined benchmarks, especially in cases where the occupation is clearly in bad faith. Lastly, time limits on municipalities. If a court orders a municipality to provide alternative accommodation, they must now specify how long they have to do so. No more limbo, no more ghost orders haunting budgets for years. But here's the deeper truth. Not every occupier is a villain, and not every property owner is a saint. We're dealing with an emotional minefield. Generations locked out of land ownership, young families squatting on plots to survive, unscrupulous groups weaponizing poverty, and small landlords losing homes they once saved decades to buy. The line between desperation and manipulation is paper-thin and soaked in the politics of pain. Where does this leave us? The bill is still on the floor. Public consultation awaits. It may evolve, sharpen further, or soften under scrutiny. But make no mistake, we are not just debating an amendment. We are debating the future of dignity, of ownership, what it means to be South African in a country still trying to reconcile freedom with fairness. At ST Law, we're watching closely because we believe that the law should serve both justice and clarity. If you're a property owner struggling with occupation issues, or an occupier facing an uncertain future, don't navigate this alone. Get informed, get advice. The law is shifting, and where it lands will affect us all. This is not just law, it's legacy. And every line we write now echoes into the soul of children will inherit.